So thank you very much for everybody that's joined us. Let's get started. I'm Heidi. I'm the CEO of the Lettings Hub. Lettings Hub is a long-established kind of company that provides solutions to the lettings industry, from pre-tenancy platforms, referencing, insurance, utilities, and much more in between. But more importantly, let's kind of introduce my guest today. So Carly, if you could introduce yourself and Woodstock, that would be great.
No problem. I'm Carly Jermyn. I'm a director and solicitor at Woodstock Legal Services, and we specialise in residential landlord and tenant law. So obviously the reforms are a big deal for us. So we've been spending a lot of time looking at them and how it might impact the work that we do for our landlords and agents.
Okay, excellent. And we also have another special guest today, which is David.
Hi, thank you. My name is David Gibb. I'm the operations director here at Tay Letting, based up in Glasgow. We're an agency that operates throughout central Scotland with branches in Glasgow, Edinburgh and Dundee. And we have around about 2,000 properties currently under management.
Okay, thank you very much. We invited David along because obviously Scotland have gone through many changes in previous years, and his experience, I'm sure, is going to really help us. So in terms of the agenda today, what we plan to go through is we plan to kind of talk through the reflection on the key areas of the Renters Reform Bill and how we can all prepare for these changes. Carly's going to talk us through what the main changes are and the key things that we're learning as we go along. We've obviously got a live Q&A. We've already had quite a few questions submitted before today, so we're going to do questions as we go to make sure that everybody's getting the best out of the session. So, Carly, over to you, if that's okay.
Thank you. When I was asked to talk about this, I thought, there's been a lot on the reforms, and I think there's been a lot of coverage of what the 12 key changes are. And whilst it's important for us, I think, to look at all of those changes, actually, when I was looking at it, I broke them down into 5 areas. And looking at those 5 areas, it really helps you understand what they're trying to achieve and what the sort of the cultural shift is, generally driving up standards and professionalism and restoring a balance in the private rental sector. And I thought if we look at those 5 key areas and the impact and the changes within those areas, it's a really good way to analyse it. So looking at the reforms, their ambition, as they state it, is to deliver a fairer, more secure and a private rental sector of higher quality properties. Higher standards of actually the quality of housing, and for tenants to be able to consider the property is their home. And this is a conversation I always have with landlords, and I think this goes to the root of their frustration, is getting them to shift from it to being their property, their home, that they previously lived in or they've purchased and they've got an emotional attachment to it, and looking at it as a tenant's home. And the objective of the Housing Act, the legislation originally was never to have 6-month tenancies, and it's evolved, and actually they're looking about how do we get it back so that there is more security of tenure and longer tenancies, and we've got people in one property for longer, and getting landlords to look at it as their asset, and they've got to look after it in a professional way. But at the same time, the reforms are addressing how landlords should be able to repossess the property should it be necessary, and that we've got effective resolution to these issues. We know that there's an issue with the courts at the moment, and there has been for a long time, even pre-pandemic. And then looking at the local authorities' tools for enforcement. So then when I looked at it and looking at the 5 areas that we look through, starting with is a general positive renting experience for all, and we'll talk about what that means. We'll look at more at the security and stability and the introduction of essentially periodic tenancies. What it means with safe and decent homes and the quality of housing, the reformed grounds for possession, which are really key, and then improvements for dispute resolution process and what changes we've got there, looking at those 5 key areas of impact. So let's have a look at the first one. So the first one, the key thing I think we've all seen in the press is and it's been talked about for a long time, is making sure that there's no blanket ban on tenants with benefits. You quite often see adverts for no DSS, and also more recently I think you've seen bans on people with families. I've got 3 children myself, so I can probably understand landlords' concerns there with the impact on the property, but what they're looking to do is ban that, because the private rental sector is many families need to be renting in the private rental sector, as do people on benefits, and so having that as a ban, and to support those who are letting to those on benefits as well. And they're also exploring potential ban on prison leavers as an extension to this. And then another key thing is banning refusal of pets. So what they're bringing in is tenants will have the right to request pets at the property, and landlords will have 28 days to respond, and they'll be unable to unreasonably refuse. One issue there for me is leasehold properties, where the lease may prohibit pets being in the property, and I suspect that'll be and will be an issue, potential way that they can refuse pets to come into a block there. And these changes will kick into, they have a ripple effect. So we'll have to look at the amendments to the Tenant Fees Act, and looking at the permitted payments and discussion around tenants' pet insurance, and that becoming a permitted payment, so that we open up the payments there, so that landlords can protect themselves. Because previously, of course, you take bigger deposits, that sort of thing, but that's no longer able to do that. So they've had to look at workable solutions there.
I think there's so many things around this, and pets actually came as our top question in terms of questions submitted so far. So we may as well kind of tackle it at the top. Before we do that, though, just going back to the selection against tenants, that's going to be difficult. I think we've seen in industry press this week already that there's now 11.7 tenants to one property, which is up from 7.8 tenants back in February. So it's only on the increase. There's obviously a talk about whether landlords will exit the market or not, and therefore will that kind of put that even under more strain. And therefore, with tenants that are coming through with circumstances that might not be ideal for a landlord, are they ever really going to get a look in, and how is it going to be policed in terms of whether those tenants get into property at all? So I'm interested, David, really in terms of what actually happened in Scotland when changes like this came in, and did we see a mass exodus of landlords from the market, or actually did it settle down fairly quickly?
No, we didn't see the mass exodus, and that's the point I tried to express in my article last week. The changes that came in were fairly substantial, and more so, we don't have the pet issue yet, but that is coming for us as well. But again, as an agent, we will look. We're in a similar situation whereby we are seeing an increased demand for properties. And if people are coming to us and they have 2 cats and a dog, as opposed to we have a young professional couple, we're going to go down the route of the young professional couple in the first instance.
And Carly, how have you got any inclination at all about how the government might police that? Because obviously, how is it going to is there going to be any change in terms of discrimination, or do you think it's just going to stay the same?
Yeah, I think I'm with you. I think given the demand, I think it's going to be really difficult for anybody to pinpoint that's the reason they were refused. I mean, there may be cases where, they are able to prove that's why they were refused. But, it's going to be a big challenge for anybody to say that's why I was not given that property when you're competing against 10 other people. And I think what's really important is for agents and landlords to look at their just protecting themselves against those sorts of accusations and claims. And it's looking at the training, looking at how you're marketing properties, and how you're onboarding people, and making sure that that's all considered. And I think if you protect yourselves there and you've got decent processes and you're checking what's going out on your marketing, then I think it's going to be really difficult for them to establish that that's the reason they were not given the property. So whilst I see why these have been brought in, I think the actual impact's going to be fairly nominal, to be honest, given the market we're operating in.
Yeah. And in terms of obviously pets in property, like we said, we've got the first question. It says, what are they putting in place, if anything, for the protection of the landlord's property from damage from a pet, as current levels of deposits would not cover it, especially if the tenant doesn't pay the last month's rent? That question's coming from Rachel. Do you want to just kind of take that one, Carly, in terms of what you think the government might do based on what we know so far? And then I can talk a little bit about more what we've seen in terms of some survey results and other things.
Yeah, I think, like I said, we're looking at the Tenant Fees Act and permitted payments and insurance. I suspect that will be become fairly commonplace.
Yeah, and we met with advocates last week who have done a recent kind of survey called What's the Damage? And they've surveyed just over 500 landlords and letting agents in terms of, well, what is happening in property at the minute? Are pets causing damage? If so, to what extent they're causing damage? And what's likely to be the solution the landlords and letting agent want to the problem? And the 4 options that have kind of, were discussed on the questionnaire were, do you just take an extra week's rent as a deposit? Do you take a separate pet deposit? Is that allowed? Will the tenant be made to have insurance? Or actually, does the landlord want to hold an insurance policy where the tenant has to pay the premium for that insurance policy? Because the other three options are a little bit fraught with risk if we kind of work them through. Because if we take the average damage from a pet, it's well over £250, let's say, in terms of what's likely to happen. And therefore, if another week's rent is taken, it's not going to cover necessarily it. If you're taking an extra amount from the tenant on top of the rent, you're going to have to take a long while to get a big enough pot to necessarily pay the claim, especially if tenancies are obviously going where a tenant can leave after 2 months and tenancies potentially are going to come shorter. That's kind of one thing I think that you've mentioned, David, that's kind of happened in Scotland as some of the changes. So it would be good to just get your view on what's likely to happen here in England and Wales.
Yeah, I mean, certainly in terms of the deposit in Scotland, we're capped at 2 months of the rent that we can take. And that then does throw up a question. If a tenant moves in and then contacts us mid-tenancy to say, you know, I've bought myself a Great Dane, what do I do? You know, and the pet's already in the property. It's very difficult. We would normally then ask them to, you know, pay an additional amount on top of the deposit. But if you've reached that limit, you're tied. You can't take a separate deposit because the law up here is, you know, specifies maximum you can take is 2 months. So I think, you know, they're going to have to work on the logistics around how they support landlords and protect landlords when they bring this in, because it's still a minefield up here. We can evict a tenant for a breach of tenancy, and I'll come on to this later, that again has its own issues.
Yeah, and I think as well, I mean, if you take it, one of the key things that insurers say to us is a pet's most likely to damage the property sometimes in the early days of that tenancy because it's got new surroundings and obviously it's getting used to circumstance. If, for example, £25 was added on to the monthly rent and, you know, you're 2 months in, you've only got £50 in the bank to be able to deal with any remedy. If it's held in a deposit, you can't necessarily access that till the end of the tenancy and you're still in arbitration potentially with the tenant. And if the tenant holds insurance, you've still got to rely that the tenant's paying the premium, that the tenant is willing to make a claim on that insurance policy because it's theirs, and also that actually that policy is fit for purpose because it might not be. So it becomes kind of another burden on the agent to check that. So from my point of view, personally, I think an insurance policy that the landlord or the letting agent can control, but the tenant has the responsibility to pay the premium, is probably the sensible way forward. But obviously it's all kind of the devil's in the detail of the bill, I think.
Yeah, I agree with you. I think that probably is the most sensible solution. And I think when there's huge concerns about the cost of living and the increase in, you know, rent anyway, I'm assuming that an insurance policy is going to be cheaper for everybody all round than it is, you know, to increase rent. So I think that's probably the best solution all round, in my view. But yes, you need a good agent that's on top of those policies and that are reacting when there are issues, making sure that you're complying with the terms of the policy, gathering the evidence that you need. So it all comes back again to processes and management. And I think, you know, all of this is about driving up standards, and agents, in my view, and I've been saying this for a long time, even before these reforms coming in, play a really, really crucial role in making sure that they are, you know, protecting their landlord clients and making sure that they're complying with, you know, on their behalf on all of the responsibilities, or assisting them to be able to comply with their responsibilities. Or professional landlords that have got a decent sized portfolio, know what their responsibilities are and have good systems and processes in place, so if they have issues with pets or their insurance policy, they're on top of it all. So yeah.
And, you know, at the end of the day, that's protecting the agent's management fee, which is important, and obviously providing them with their income. They want minimal disruption, I'm sure, to just letting out property fairly easily.
Yeah.
Okay, so what other changes have we got coming then, Carly?
For me, this is the big one, I think, and I think this is the big one for everybody. The increased security and stability. We talked about that it was never the intention for there to be 6-month tenancies in this big turnaround. And it's interesting because we're all talking about increased security and stability, but actually we're probably more geographically mobile than we ever have been in this day and age, particularly where people can work from home. So it's an interesting move, and I understand the importance of it. And I've talked about how for me it's really important that landlords understand that that a property that is let is a tenant's home and it's their asset. So this is all moving towards that. So the key change is essentially moving away from assured short-hold tenancies to putting everybody onto periodic tenancies. And this will happen because tenants can at any point give 2 months notice. And that it previously
even when they move in, on the day they move in.
That's my understanding. I need to double check it, but at the moment I haven't seen that there's going to be any sort of period where they can't do that. I think, David, did you mention that it's different in Scotland, that they have?
Yeah, it is.
Yeah.
I mean, it's a lot harsher in terms of tenant can move in and give us notice the following day, and they only have to provide 28 days notice. So it's you really need to make sure that the tenant viewing the property, that you've gone through the checks with them, you've vetted them. One of the key questions: why do you want to rent the property? You need to understand.
Yeah, quite.
That from the get-go.
Yeah, I agree, and that may become more of an issue than the pets and the children. Actually, what's your long-term connection to the area? Are you sort of establishing those questions and understanding, like you say, why somebody wants to rent a property, and are they likely to be a flight risk as such? There's some benefits, because previously, after the fixed term, it was of course just 1 month notice, so at least they're getting 2 months notice, so a slight amount of compromise. But yeah, the 2 months is a big change. It really is.
Yeah, I think it's a massive change. And at the moment, some agents, I'm sure, having 1 month's notice doesn't really matter, because there's so much tenant demand, they can fill the property fairly easily. I think the key thing is going to be turnover of tenancy, and it costs the landlord money. Now that there's no charge to the tenant. So actually, looking for tenants that want, or say they want to rent long term, is going to be, probably very appealing. And what about then how do we think then it's going to? I suppose I've got two questions. What about the student market, and how's that going to work? And then secondly, I suppose one of the things that we talked about earlier in the week, Carly, was about holiday lets. As in, why is it now actually we're kind of crossing into that territory where why don't you just kind of pick a house that you'd quite like for the summer for a couple of months, and it's way cheaper to do that than book it out for a week potentially.
Yeah, exactly. And so it'd be interesting to see the impact on that market as well. And those that were previously operating tenancies under the guise of a short-term let, you've had it that way, but also, the short-term holiday let market's been a really, good economy, I think, for a lot of people. So it'll be interesting to see the impact there. What they're talking about, that will be introduced into 2 phases, I think it's important to note. Same as they did with the Tenant Fees Act. So we're apparently going to get 6-month notice of it being implemented for all new tenancies. And then I think there's going to be at least 12 months before it's implemented to impact on all existing tenancies. So we've got some time, and it will be interesting to see what happens with the new and existing tenancies from the first point of inception to then, how it will impact the rest. So we'll be able to monitor as it goes. Section 21's going to be scrapped. I think that's no surprise to anybody. We've been talking about this for a very long time. And then the Section 8 grounds are going to be extended. And I will go through those, but the devil really is in the detail. And just to mention that purpose-built student accommodation is exempt. But I do think consideration for anybody, any landlords or agents that are, dealing with private houses, student accommodation, be interesting to see the impact there on, them regaining possession for the summer.
Yeah, just coming to David, what's happened to tenancy length, I suppose, in Scotland since your changes have come into play, and has it been that dramatic?
Yes, we have. We've actually, and again, when the government in Scotland introduced the new legislation, the similar thing was to provide more security and more stability, but we've actually seen average tenancy times drop.
Yeah.
So with our old short assured tenancy regime, which was similar to the AST in England, we were seeing 26 months as the average back in 2016-17. We're now sitting around about 18 months as the average tenancy under the private residential tenancy. So it's shortened. It does give tenants more mobility and more opportunity to move. The other interesting point was the student market, and again the same thing happened here. Student blocks were exempt from the new private residential tenancy, whereas houses providing shared accommodation for students were. landlords really used to rely on the academic year, and then they could, flip the house back for the Edinburgh Festival, for the holiday period in Scotland, and then set up a new tenancy for September. That's kind of gone now. Landlords can make an offer to tenants to see if they want to move out, but some tenants will just sit. There has been a spike in tenants renting their properties out over the holiday period, which is another thing. So that's one thing to be aware of. We did capture a lot of our properties going on Airbnb. For example, the Edinburgh Festival is a very attractive time for people to make money. A lot of people coming to the city, and a lot of students were using that. So it's one thing to bear in mind that you can't now rely on that fixed term. It's gone, and I think that's what a lot of landlords struggled with to begin with. When
and I think a lot of landlords use that fixed term. Sometimes, absolutely, Carly, I take your point that it's an asset to them, and lots of them, have a buy to let and they use it for a reason. But we've obviously seen in more recent times, landlords renting out their own home because they, they might need to work abroad for a year and they're coming back, or a whole variety of situations. So having an agreement with a tenant that they're moving in for 1 year, and that's the agreement of that tenancy, often works for both parties in terms of what it is that they're agreeing to. Obviously, from our point of view, we're already starting to think about, referencing changes, insurance potentially changes. So for referencing, obviously, when we're making a decision about somebody's affordability, we're looking at obviously how much they earn, but over, is it the whole length of the tenancy, or actually is it for a part of that tenancy? And actually, if we don't know how long that tenancy is going to be, we're going to have to be making different decisions as we kind of go along. One of the questions that we've had in, and I can see them coming in, is one from Stuart, which he says, as an agent, what do they need to do now to get ready for these changes, especially on the change in tenancy length? What advice would you have?
I think my advice with all of this, and I don't think this, differs on this particular issue, is just knowing your portfolio and making sure that and your processes, and looking at your referencing and all of your systems that are as robust as they possibly can be, and that you've got the right people aligned with you to give you support. And I'm not just saying that because that's what we specialize in, but the reality is there's going to be lots of questions, lots of litigation around some of these issues. So I think that's how people get themselves prepared. And I think at the moment that's what you do, you're getting your house in order. And I think one thing I just wanted to pick up on is, I think a lot of people won't, because we're sort of very landlord focused, but actually, and going back to students in particular, whilst tenants, have got this ability to give 2 months notice, it doesn't mean they're going to do it right and they're going to do it properly. And so that's going to be really interesting, because I can imagine there's going to be lots of discussion, conflict, and perhaps even litigation around whether a notice has been technically properly served. And you can, students, in theory, if they don't want to be liable for that property over the summer, they need to serve their 2 month notice. And looking back to when I was at university, we had lots of other stuff going on, and would somebody have done that properly for them? I don't know. So, there's lots of issues. So is a lot for tenants to learn as well.
Okay.
And, agents have got to navigate that a little bit, because I know they'll be giving assistance to tenants.
I would agree. I would agree with that, Carly. It's about, and going back to the question as well, it's about speaking to your landlords, having regular conversations with them before the legislation changes, just make sure it's front and center. Because you don't want it creeping up on your clients.
No.
I suppose as well, though, David, isn't this a massive opportunity for the landlords that the agents don't currently have a relationship with, or have a very limited relationship with, maybe on a tenant find only basis? Because the amount of legislation in our industry already is huge. And with more and more coming and more changes that a landlord doing it alone has got to comply by, surely there's an opportunity to drive potentially more landlords into the managed market.
Indeed, there is, and we did see an uptake in our fully managed service after this. People were starting to realise just how much of my time is this taking up. How can I keep up with all these regulations? For my whatever percent you pay, I'm just handing over to an agent. They'll keep me compliant. They'll keep me right.
So, I think so.
I suppose that's where then obviously rent controls, because in that scenario, if you're a landlord and you think, okay, well, all right, I'm going to pass it on to an agent to manage. I'm going to take a X% management fee, and therefore I'm going to really put the rent up to cover that. did that happen? And obviously rent controls are not talked about yet. I suppose the question to Carly is do we think they're coming? Because obviously I suppose the reform as it currently stands could have been worse.
Yeah, it could have been. And you can see, it's an obvious knock-on effect, isn't it? Increased rent with a lot of these changes. So yeah, I mean, it's one to watch out for. And I'm pleased it's not been put in, because I 100% agree with Dave. And I've been saying this a long time, even before this coming in. It's a full-time job doing this. It's a professional business. It's a service, and it needs to be done by really, high quality, good agents. And I know for a fact, if we're working with really good agents, and we work with some fantastic ones, they've got great systems and processes. They will eradicate more problems from the off, because they'll deal with them effectively, and they have better referencing. They're more astute as to what sort of tenants may cause problems, that sort of thing. But actually, when you do have a problem, it's so much easier for us to resolve because they've got great systems and processes in place. And that will come into play when I talk about the grounds. But I 100% do agree with David. Pass it over to a great agent. Otherwise, it's a lot to navigate. I wouldn't want to do it. In fact, I've got one rental property that I'm, and it's a lot. And this is what I'm trained to do. But I can't do it alongside. It's not something you can do on the side. It needs your full time and attention.
Carol, you mentioned the key word there, which was that it's an asset. And with other financial assets, you employ the services of a professional service.
Protect it, to help you protect it.
Exactly that.
So just one final question on this, Carly, that's coming from Steve on the chat, and then we're going to move on to the section notices. Is there any indication on how an individual notice will be handed in on a joint and several leases under the new reform? Is the question.
Well, yeah, that's a really tricky one. I don't know, because if one tenant tries to terminate the tenancy and serves notice, then will it be? I suspect it will. I don't know. I suspect they'll have to do it together. I don't know what's happened in.
I can tell you from experience in Scotland that it has to be both. Has to be all tenants.
Yeah.
So the provision in the private residential tenancy allows you to communicate electronically.
Yeah.
But the tenancy agreement has to have the email addresses that you're going to use, and it's the tenant's responsibility to keep that updated. But when it comes to giving notice, it's all tenants on the list must be copied in, and the agent again has to just ensure that all tenants have been copied in on that email notice. So.
Yeah, and that just shows you how easy it's going to be for tenants to get it wrong. So it's really important. And going back to student accommodation, a good agent should be reminding students, now's your time to give notice. Do you want to give us notice, and agree that it terminates on this date, and agree to surrender, and do the hard work for them to make sure that everybody knows where they are. But I think there's going to be, whilst this is in theory a bonus for tenants, they really need to know what they're doing. And like you say, if one gives notice, doesn't include the other, or it's not served properly, then there could be real problems.
Yeah, and I suppose on the student market, it's going to be interesting of, whether students, start in one way to kind of bypass an agent, in the fact that, their friends are in a property, they know which property is going to come up, they know that those people are going to, move back home because they're at the end of their university course and are near enough, finding the properties themselves before they're coming to market, which is going to be a bit of an interesting change. So let's move on to the section notices. So Carly, we've got one question in, which if you can include in kind of your answer would be good.
Sure.
This is from another Steve, and it says, do you think landlords may abuse the new grounds under Section 8 to recover their property when a Section 21 is abolished? E.g., for example, stating they want to move back in and issue 2 months' notice and then change their circumstances. That's one key question, I think, and how is it going to be policed?
Yeah, so when it comes to selling or moving back in, neither of those can be relied upon until after the first 6 months. And then my understanding is there is a ban, therefore, on remarketing the property, and that's how they would police it. In theory, police it. That's going to be very, very difficult, and you're going to be relying on a tenant who's moved on or somebody to notice that they're remarketing. So it's very difficult, I think. I think policing that's going to be very difficult, and it'll be really, really interesting to see how those two grounds pan out. And when it comes to sale, which is one of the new grounds, and moving back in, there's two issues. I mean, what stage do you need to get to the sale? Does it just need to be marketed, sale? What evidence do you need to present to a court to satisfy that ground? And the same with moving back in. What constitutes a close family member? Again, there's more detail needed. We don't have the draft bill yet, so we need to wait and we need to see, more detail, essentially. But there are two of the key introductions into ground A is sale and moving back in. Some other changes that we've got are antisocial behaviour. This all comes back to what they're trying to do is protect responsible landlords, lettings agents and communities as well. And that's why there's been a focus on antisocial behaviour and trying to expedite that so that we can get possession more easily than we can with antisocial behaviour. We constantly deal with cases where there's antisocial behaviour, but it's hard to evidence, particularly if somebody's not kept a really decent, accurate record. And so that's why people have relied on Section 21s for this sort of thing, or just rent arrears and not bothered to include the antisocial behaviour and just done it on the 2 months rent arrears. But what becomes really important with all of these grounds, and I'll run through the rest, but is evidence. And it's collecting, statements from neighbours. If you're in a block of flats, information from the management company, police reports. Can you liaise with the police? Will they look at a closure order? Can you work with them on it? So all of that collaborative working becomes really important. And again, it's back to agents to make sure they're keeping records of complaints that come in. So if a landlord says to me, so-and-so is complaining in the block, what can I do about it? That they speak to them. They take, their evidence, in fact, that, solicitors like us can then rely on, that we can include in the Section 8 notice, so that tenants know exactly that we've collected all the evidence, we've done our hard work, there's no point challenging this, you need to move on. So yeah, I just think it's really important. Systems and accurate record keeping become really, really important. The other key change, they're maintaining the 2-month threshold for rent arrears, but the notice period will be extended to 4 weeks. I don't see that as a huge surprise. I think that's probably fair. 2 weeks is pretty short for anybody to, find and move on, particularly if you've got a family to relocate. And, my advice to landlords and agents is to, what we do at Woodstock is we generally try and look at alternative solutions instead of pushing through to court. And this is the way all of the reforms are going. Talk about mediation, we're removing Section 21 accelerated possession procedures, just pushing a claim through court on no fault. And actually what they're asking people to do is come together and discuss and see whether they can come up with a solution. And that's what we've done. And we've done it historically. We did a huge amount in the pandemic, looking at early intervention and seeing where we can reach, resolution with tenants. It prevents court fees, it prevents, time and wasted effort and emotion for everybody. And actually, quite often it can be achieved. And we've had great success doing that. And that 4-week period, that's what you should be doing. Landlords should be serving notice at the first available opportunity to protect their position. Doesn't have to be an aggressive letter. You're inviting tenants to discuss with you and really see if you can work, an amicable solution, but protect your position at the earliest point you can.
Yeah.
And and then the other ground that's been introduced, which I think is a real positive, is the persistent arrears. Previously, we've relied on grounds 8 and then 10 and 11 discretionary grounds for just in case they dip under that. But this gives landlords a little bit more, so that if there's been at least 2 months arrears 3 times in the previous 3 years, that they can also gain possession. So I think that's really helpful because, we've seen it time and time again. They dip below 2 months just before the hearing. They're fully aware that puts them in a better position. You might get a suspended possession order. You might not get one at all, depending on the judge on the day. So I think this really helps landlords. But again, it's accurate record keeping and making sure agents have got really good systems and processes, that their rent arrears schedules are really accurate.
Yeah, and I think sometimes the key thing there is demonstrating to tenants that the agents have got control as well, because I think that's where there's potentially, tenants sometimes will obviously try and find a loophole and try something on, where actually if there's evidence that the right information has been given at the right time and there's evidence of that, and that can be proven really quickly, and actually if the tenant can have visibility of that at the same time as the agent can have visibility, then even better in terms of being able to, kind of squash some of those. David, is there anything kind of, worth mentioning from your side on what's happened in Scotland?
I mean, our experience, again, going back to giving specific grounds to leave, sale, moving a family member in, I'll be interested to see if the UK government come up with the same definitions of family members as the Scottish government did, but because the list's as long as your arm.
I can imagine.
In terms of providing evidence, we generally find if we notify a tenant the owner's looking to sell, we very rarely get asked to provide any evidence of that. However, we have had some cases where the owner has had to provide an affidavit to confirm they are, moving back in or moving a family member into the property, where the tenant has indicated to us that they don't intend to leave. And then that is been used to support our eviction case. So it's just something to bear in mind. You may want to, if people think, just say I'm moving my sister in, that sometimes might not work for you.
Okay.
In terms of arrears, it's the same. You know, Carly's hit the nail on the head. It's evidence. It's building that case. It's showing in Scotland we have to show that we've gone through specific steps with the tenant and referred them to your citizens' advice or other agencies who can provide support. And if you can show you've done that, you can show you've tried to work with the tenant, and the arrears are not resolved, you will find that when it goes to court that you're in a pretty strong position.
Okay. I'm just conscious of time. We're probably going to go for another sort of 5 more minutes. I suppose one of the key differences is in Scotland you have specific courts to deal with this, and this is obviously one of the key concerns here in England, that we don't and won't potentially.
Yeah, no, that's correct. I mean, with the new legislation came the Housing and Property Chamber, which is still part of the Scottish court system. But again, it's more driven to the first hearing is a case management discussion, where all parties are invited along to have a discussion to see if the situation can be resolved without the need for an actual hearing. Again, if parties can't find common ground, it will go to a full hearing with a legal member of the tribunal who will then make a ruling based on the evidence presented by both parties.
Yeah. And obviously from our point of view, selling, rent and legal protection insurance, we've already seen kind of a demand coming based on, the cost of living going up, and therefore, tenants potentially more likely to fall into arrears. What do we think maybe, Carly, is going to happen if tenants can leave more freely, in the fact that they're not stuck in a longer term tenancy? Like they might have just signed in for 12 months and suddenly lose their job and they feel a bit worried. Obviously, in this world, in reality, they could give 2 months notice and go. Do we actually think that's going to happen? Because where are they going to go?
Exactly. Yeah, I think they hold the cards, unfortunately, still. Where are they going to go? Demand's really high. And actually, they know that it's, a landlord's got hurdles to get through. The courts are going to be even busier. I see more litigation, not less. I don't think we may see marginally less claims for possession, but they're more involved, they're more protracted. Everyone needs their day in court, so that means it's slower. And it sort of brings us on to the reforms. We talked about no housing court, but they are targeting areas of unacceptable delays, and seeing, because the court system is not fit for purpose, and the delays we see for our landlord clients is beyond frustrating, and that to me is the biggest hurdle of all these reforms, and they really need to focus the time, attention, some money on it, and I think that's going to be a really tough challenge. So I think, like I think tenants hold the cards, unfortunately. So if you're struggling with your arrears, and if landlord's going to struggle to enforce against you, then you're more likely to stay put, because, like you say, where do you go? And it's going to take them a while anyway. They know that. So unless courts sufficiently speed up, I think again, it's still going to cause problems for landlords. But they are looking at the county court bailiff capacity, and that's been a problem for a long time. Interestingly, we've seen county court bailiff appointments speed up, because for a long time we were pushing for high court enforcement. Actually, there's not that much difference at the moment, so that's interesting. And prioritizing cases.
I think with courts, though, there's still big backlogs, isn't there? It's never really recovered from COVID times. And so if your tenant goes into rent arrears and they're not willing to move out, you are in it for the long haul at the moment, unless mediation is going to work. And obviously mediation's massively got a place now. But if that fails, you are in for a long run. Is that fair to say?
Yeah, definitely. And I think it's going to take a long time, a lot of effort to get to improve things. So yeah. And you mentioned mediation and ADR. We do huge amounts before we get to court. Naturally, I think it's the right way to be going. They've introduced mediation during the pandemic. I think the impact of it has been not as big as everybody thought it would be. I think most of the time, by the time you've got to court, the relationship's broken down. And if you've got, decent advocates on your side before you get to court, those options have been explored, and normally we're beyond that, unfortunately. So I think unfortunately it's still going to take a long time, and that's why, again, it goes back to agents and their processes and the evidence, because if you're going to go to court, you need to make sure that when you get there on the day, you're confident in the case that you're presenting to the judge. They're grappling with new legislation. They're not housing specialists. They may be generally doing family law. We're not having a specialist housing court, so it becomes incredibly important that agents and landlords and their legal advocates advocates are doing a really good job on the day, and they present the best case on the day to avoid any further delays.
Yeah. Okay. I've just got one final question, and then we'll just kind of, I think we're running out of time. We need to close. So the question has come in is, what are the loopholes do we think both landlords, the key loopholes that both landlords and tenants are going to use to try and get round the legislation that's coming in? What I suppose are the biggest risks that we're going to face? David, do you want to give us kind of your view?
Yeah, I mean, certainly speaking from experience, that landlords, when the legislation first came in, it was, I'm moving my sister in, I'm moving my cousin, I'm moving my auntie, and I'm moving, you know. Now, it's only a problem if it becomes a problem, if the tenant challenges it. Likewise, when a landlord withdrew a property because they were going to sell, if the landlord then puts the property back on the rental market and the tenant sees that, that's when it becomes a problem. We've not had many cases in Scotland, but they seem to be on the up. So I think in the last sort of year, I've seen about 10 or 12 orders being made against landlords, and they can be fairly substantial fines. It's 6 times the monthly rent is the rent. So in Glasgow and Edinburgh, average rent's about £12.50 per month. That can be a big number if you're thinking of using a ground that isn't actually applicable. Yeah, sure. And Carly, what would be your summary?
I think you're right. I think that's going to be where landlords are going to try and work the grounds in their favour. I think it's risky, but I think it's also equally, I think it's really difficult to police. And we've talked about, well, I don't know actually have, but they're putting some more clout behind enforcement for local authority. But how effective is that? That will be, I don't know. They're looking at giving them more investigative powers, all of that, but it's got to be really effective. This is, the private rental sector is huge, and there's a lot of cases to monitor, and I can see those 2 grounds are going to be the really interesting ones, I think.
Okay, right. I'd like to say thank you to everybody that's kind of sent through their questions. Really appreciate it. I appreciate we haven't got through them all, because it's obviously been quite a lot to cover in a short space of time. There's loads of change coming, I think, is the summary that we can kind of all take away. So what happens next? After this session, anyone that's kind of joined will receive a link to the recording if you want to listen back at any time. The email will also include a link to find out more about us and Woodstock and everything that we do in terms of solutions that we potentially have to help. Although obviously I think we're all finding our feet at the minute as the legislation becomes clearer. And we obviously plan to run many more webinars over the next few months on this and some of the right to rent changes coming and a whole host of things that are going to kind of impact the industry. So thank you very much, Carly. Thank you very much, David. It's really appreciated.